Welcome to a Wiser Retirement podcast. Before we get started with the episode, I wanted to let you know about a new free ebook available on our website. This ebook goes over the top reasons most financial plans fail and covers what a quality financial plan should consist of. The link to download Top Reasons Most Financial Plans Fail is listed in the episode notes. Now on to today's episode.
Welcome to a Wiser Retirement Podcast. We believe the best financial advice should always be conflict-free. I'm your host, Casey Smith. With me today is a special guest, Doug Butler. Hey, Doug.
How are you? Thanks for having me.
Glad to have you back. Doug's an attorney at Morgan Johnson Steele. You guys do a lot of estate planning work for us, and we appreciate all that you do. And you're a two-time podcast participant now. There's only a few. Hadley, we should have badges for people that that come here more than once, right?
Well, I appreciate you having me back. I had a great time the first time, and I'm looking forward to having some more fun today, talking estate planning, which most people don't think is all that fun to talk about, but it's a vitally important component of anyone's financial planning. So
yeah, I have found it's hard to move some people to get their estate planning done. It's not a fun topic, but the consequences of having nothing done is also pretty detrimental. I appreciate the work that you and your team have done. I know we've sent a lot of people your way in the last probably year or so, maybe.
Absolutely, we really appreciate the relationship. It's been a great one, and it's not just me that works on these. I work really closely with my partners, Sean Shelton and Brian Smith. We work together as a team.
No relation to me.
No relation to you. Yeah. Got to disclaim that. But we Brian and Sean have been working on estate plans for 20, 25 years together, aggregately 50 years of experience, and working on level one estate planning, the wills, the financial power of attorney, healthcare directives, all the way up to advanced sophisticated planning, approaching billions of dollars in net worth. So we've got the expertise and the bench depth to deal with most any estate planning.
How long have they been with the team?
Brian Smith, I don't have the exact date, but he has been there since the 90s. And
oh, wow.
Sean has been there since, I want to say 2010, 2011.
Okay, so lots of tenure there.
And Sean was
longer than you, is that right?
Well, actually, I brought Sean over.
Oh, did you? Okay.
Sean and I used to work together in the life insurance world before we went to law school. Sean was kind of my inspiration to go to law school. We worked in the life insurance space, mostly for estate plans.
Okay.
On the selling side and underwriting side.
Right.
And Sean went to Duke Law School, so he's a very smart guy. I said that might be a good idea for me, and I went to Mercer Law School. I'm not as smart as Sean. And so he was working with another firm and said he was looking for a change, and we brought him over to Morgan Johnson Steele in 2010, 2011, and it's been a great fit because he's really sharp, knows his stuff.
That's great. We need to bring them on. Have a
absolutely
have a huddle.
I tried to get Sean on short notice to join us today, but he had an estate planning meeting, so he wasn't able to do it.
Man at work. All right, so we're going to focus on dying without a estate plan. I love this title. Dying without a estate plan. Do you hate your family?
I've never phrased it that way, but that is sort of the message. We usually say,
and you might hate your family. In that case, just turn this podcast off, and
you know what you need to do.
We'll get you next week.
If you hate your family, then don't leave them. Then don't make a will.
All right. Yeah. All right. So let's run through some scenarios. So we have the Jones family, just run-of-the-mill family. Maybe $500,000 in real estate. And maybe $1 million or so in investments and such, but they did no estate planning, no will. What happens?
Well, when you start talking about real estate, one of the first things I think of is the real estate local, or is it in many different states, or different states, I should say. You may have some property, say in Georgia, and some property in Florida. Not having a will in that scenario could be pretty painful because Florida's probate process without a will, or even with a will to a certain degree, is a little bit more challenging than Georgia. So, we're going to typically at a net worth of roughly $1 million, like you said, under today's current estate tax regime, it's a pretty high threshold for you to breach that estate tax.
Yeah, it could be over to what, 22 million now?
I think it's closer to 27 million.
27
for about 13 million per married
So that's a good takeaway. There's no death taxes in the state of Georgia unless you have a net worth of well over $27 million.
And if you're an individual, it's $13 million. And you have the ability to transfer unlimited amounts
per
to
person.
Spouses. Yeah, so it's per person, roughly 13 and a half per person.
Right.
So collectively, because you can pass assets to your spouse, unlimited amount without incurring any sort of, there's no threshold between spouses. So you can transfer that 13 and a half over to the surviving spouse and then die. And if it's worth less than 27 million, that generation doesn't owe estate tax.
And there are some states that do have their own state estate tax.
That's correct. There are
separate from the federal government.
So you're going to get 2 bites. They're going to take two.
But in Georgia, we don't have that.
We don't have a estate tax here.
In Florida?
Florida does not.
Does not. Yeah. All right. Well, that's where most people live.
Yeah. So I mean, not having a will with less assets can be, and again, a lot of it's state specific. It can be challenging if you have assets that are spread about that aren't easily found or aren't the next generation doesn't know where they are. So you don't having a will names an executor whose job is going to be to get a hold of those assets that you have and distribute them according to your wishes. Without a will, you'll go through probate. If you have children and you have a spouse and there's no will, there's and the property's not joint with rights or survivorship, but just in the decedent's name. Georgia has a law where 1/3 of the assets will go. Well, first would be a year's support to the spouse, and then at least 1/3 to the spouse, and the remainder to the children.
Wow!
So,
even if they're minors.
Well, yes, and if they're minors, they would also get a year's support as well. Now, the challenge with that sounds fair, maybe, but that may not be what you wanted. It might be a second spouse. Might be.
Well, for most families, though, there's not enough money to do that.
Right.
You're going to leave the spouse with not enough money to live on.
Yeah. And if they get a year's support off the top, that might leave nothing for the children.
Right.
So, and there's some other hairy situations. Say it's
but think about that. If you had a 35-year-old male pass away, wife is remaining. There's not much life insurance. Maybe she gets $300,000, but then 1/3 of that really she keeps.
Yep.
And the rest goes to the kids who don't even know what happened.
Right.
I mean, they know dad's not there, but they don't need that money. Mom does.
Right. Exactly.
Yeah, that's a bad situation.
Yeah. So it's
or the opposite side of that. You have a $15 million estate, and then you're just passing the money directly to the kids, who that may not be your intent either, to pass it a business or whatever it is.
Right.
In thirds.
And you're going to have to sell probably that interest, and that wasn't the game plan.
And what if they're not ready to receive it? What if they're not responsible enough?
That's why.
And the court doesn't care.
That's not what the statute's not looking to deal with those sort of personal issues. They feel like the law has given you plenty of time to deal with this.
Right.
And if you choose not to deal with it, then they're going to deal with it their way, which is not the most efficient way. So yeah, I mean, typically a $15 million estate, you're going to see at least some basic level of estate planning in place, but that's going to be important there. We talked about the current estate tax threshold. It's always changing, and the current estate tax, 13.5 roughly, aggregately of 27 million total, is due to sunset in 2 years. So that will go back down to some number that's probably going to be in the $3 or $5 million range. So just because you've done some planning, it's just one data point on a spectrum.
If nothing's done, does it not go back to 500,000? Do you know the exact number?
It wouldn't go back to 500.
Okay.
It hasn't been 500,000 for quite some time, since the late 90s. It was 675 when I first started getting into life insurance.
So that's the worst case scenario.
There was the Bush tax cuts where it was where they changed the estate minimums to $1 million, and then it went up to $3 million, and then it went back to $1 million. So if it sunsets, I think I'm not prepared for that
$1 to $3 million range.
Most folks think that something would be done. It would be a stopgap where they do something else and they, let's make it 3 to 5 for the next 10 years. And it's going to depend entirely what the administration is as well.
That's detrimental to a lot of families. Just think about your $250,000 home that's now worth $800,000 since that came out.
With inflation that's happened, going back to what it was 10 years ago isn't really fair either, because those value of those assets is going to be much more, and you're going to be paying and it's 40% estate tax.
Right.
And so
but all the money goes to great programs.
It's spent very efficiently and in a way that you would want it spent. But,
right.
I saw a stat not long ago, or I've known it for a while, but I was reminded of a stat that, estate taxes generate about less than 0.5% of the government's overall revenue. It's really
as it should be. If we lived in Russia, it'd be different.
Yeah, it's really small percentage of. So this thing really becomes kind of a political football when it comes to Democrats, Republicans, because we need to change this. The rich are getting away with a lot, and the rich are saying this is our money we work for. It really doesn't. It's really a political football. It doesn't move the needle in terms of what gross revenues to the
until it comes back to 3 million. Then it does.
It will. Then it could very much. Yeah. That number could go up. So, but it's a. And it's an interesting dilemma, but you've got to back to the point. Not having a will, not having a financial power of attorney, and not having a healthcare directive can leave your kids in a. That's what we call our level 1 planning. Basically, that's anybody and everybody that has anything in their name, they should have those 3 documents in place.
Right.
And some folks think it's expensive. But it really is to while I don't say, do you hate your family if somebody walks away and says it's too expensive, I do say it's one of the nicest things you can do from, after the fact. You're going to, from the grave, for lack of a better phrase, because it makes things so easy. They've got a lot of other things that they're going to be grieving. They're going to be missing their mother, their father, their sibling, their aunt, uncle. They don't need this added pressure of trying to figure out how to probate things. And to be honest, they're probably not going to be thinking as clearly when it comes time to do it.
You're right.
And they might make some mistake, just gloss over things that Georgia's fortunate. We have a pretty, compared to other states, a somewhat easy to use probate process, but it's still not nearly as efficient as walking up to the probate court with a will saying, I'm the executor, here's what needs to happen. You can have the thing knocked out and,
but that's
fairly short time. After COVID, the probate process is taking a little longer, but.
So we should be clear that a will is for after you've passed away, but a power of attorney and a medical directive is why you're living.
While you're still living and you're in it.
And that's part of the package. Yep. If you do a will, you should do a power of attorney, medical directive.
Yeah. And they're statutory forms. It doesn't really change our cost and most people's cost. Really, the hourly work is in the will, but they're statutory forms, a financial power of attorney, healthcare directive, meaning that these are forms that the Georgia legislature has essentially approved, and this is the format it needs to be in. But the financial power of attorney gives somebody your financial power of attorney. You assign someone to be a power of attorney, and they can make financial decisions on your behalf if you're no longer able to make those decisions. Well, there's different types. There's a durable power of attorney and general power of attorney, limited power of attorney. Limited would be if this person is deemed to be incompetent or mentally unable to deal with day-to-day living, then the power of attorney has the ability to make those decisions for them. A general power of attorney means you could sign one over right now and your wife could have the ability to go write checks on you. And a lot of people do that.
She already has that power. But yeah.
She'll have the legal power.
All right.
And a healthcare power of attorney, or healthcare directive as it's usually phrased here in Georgia, is in the event that you're unable to make decisions about your health care because you're either in a terminal condition or a permanent state of unconsciousness that a doctor has determined you're not going to be able to come back from in all likelihood, or more than that, almost definitely, then your healthcare power of attorney will have the ability to make some decisions. But really what I like about the healthcare directive is that it takes that burden off of the power of attorney to make these decisions because you've already articulated what you want in that document. So if you're in either of these two conditions, I want to, it's an A, a B, and a C is the way the document's set up. A is essentially keep me alive at all costs, drain the coffers and keep me alive even if I have no shot at coming back. B is let me die a natural death, but give me, make me comfortable, pain medication. And C is kind of a hybrid of the two in terms of keep me alive at all costs if I'm in this condition, but otherwise let me die a peaceful death. So it takes the next generation, your children, your sibling, whomever you name, they don't have to make these tough decisions to kind of quote unquote pull the plug. It's already been you've already said this is what I want. You're just saying I'm the power of attorney. Let's do this.
So it seems to me, and I relate everything to like aviation because I'm a big aviation buff.
Sure.
But it's kind of like if you die without a will, it's like your flight just got canceled and there's one gate agent that's making all the PA announcements and rebooking everybody, and the flight was full. So there's just like 150 people standing in line, and you have no idea what's going on. You know, you're gonna miss your connection. You're not going to make it to your meeting or to see your loved ones or whatever. It just kind of dumps them into chaos.
Yeah, no, that's a deft analogy.
No one really likes that feeling of being helpless,
Yeah.
and then having to do funeral expenses expenses are another thing, but funeral procedures and talking to people, and because you probably haven't done a will, you haven't done anything related to what your wishes are, you know, for after your death. So basically, don't do it. So let's take the conversation one step further.
Sure.
So there's the will, but then there's also what they call a revocable living trust.
Mm-hmm.
When do you think people should be making that transition from basic planning into something a little more advanced?
Well, we talked about it a little bit earlier. We're seeing more folks want to do those revocable living trusts since COVID here locally, especially because the probate process, even with a will, has been taking longer than some folks.
Longer than 6 months?
In some cases, yeah.
Oh, wow.
So it used to be, you could get probated in, a month, 3 months and be done. Now it's taking 6-8 months sometimes. And sometimes folks need that house to be moved out of the estate and moved into their name so they can have the title to be able to sell it.
Right.
And so sometimes if you have the assets in a revocable living trust, you don't have to probate anything. You don't have to probate whatever's in that trust. It's just by virtue of that document, it moves to the beneficiaries of that trust. So, some folks, we see it more because folks say, we just give them the heads up and say, hey, probate might take a minute. And and they say, well, it's not an entirely complicated document. So it's a few $100 more. We can do the revocable trust and don't have to worry about probate. And they're like, let's do that. Yeah. If you have property in other states, we see a lot. So again, we've talked about this before, but if you have property, say in Florida, which is pretty popular, they have a really, compared to Georgia anyway, a tough probate process. So,
yeah, I've heard you don't want to die in Florida, Utah, or California, or Texas.
Yeah, it could be. And some of those states have estate taxes as well. So in addition to the federal tax, but so again, that would pass outside probate. Florida, you have to hire a local attorney to probate. You can't just go do it yourself. You have to hire an attorney to probate property that's in the state of Florida. So that's an added cost. Yeah. If it's in a revocable trust, it just passes by the terms of the trust, and you don't have to worry about probating. And one other thing that we see, these are common uses of the revocable living trust. It's really good for if you become not financially, but mentally incapable. It names who's going to take over as basically the trustee of that trust,
which is more powerful than the power of attorney.
Right. Yeah.
If,
so
if banks would only realize that. Yeah. But yes,
the trustee has the power to dictate, to distribute assets.
Right.
So,
we have the hardest time with that with banks.
Yep. Banks are tough with, you typically, show them the power of attorney and they say, that's great, but we need an affidavit. We need two or three affidavits.
Well, you try to tell them it's the name of the trust and I'm next in line. And even then they're like, but we need the power of attorney. It's like, well, it's the same person, but this is more powerful. Yeah, and it's, they just don't want to move. They don't want any liabilities.
And the larger the bank, the more red tape.
Right. Exactly.
Sure.
So it sounds like the only reason why I do a revocable living trust is for probate acceleration or avoidance, really. Mm-hmm. And then
that's the main reasons. Yeah.
Reasons not to do it is not going to protect my assets from a lawsuit in a revocable living trust,
right?
Because it's your own tax ID. It's just you under a different name.
Yeah, there's not so much of an asset protection component to a revocable living trust. But it does.
You can also change it, which makes it.
You can change it. It's in your estate. I mean, those assets will be in your estate. A lot. You start talking about trust and estates. It's usually, or not usually, but it's not uncommon to have that conversation veer towards estate tax planning. You're trying to avoid estate tax. You want assets out of your estate, but you still have enough access to kind of control where they go. Or you want assets out of your estate, so it's out of the realm of or reach of creditors.
That'd be more of an irrevocable trust.
More of an irrevocable trust.
But you're giving up control.
Exactly.
Which most people don't want to do.
You don't want to give up control. So you find all these like creative trusts out there where it's like, I have some control, but not legal control. And you're trying to, and IRS gets really suspicious of some of that advanced estate tax planning because you're kind of getting the best of both worlds. My creditors can't get it, but I can get access it whenever I want. The IRS is going to say,
Yeah.
it's not really out of your estate, and we're going to include that in your taxable estate. So you got to make sure you're using somebody like a Brian Smith or a Sean Shelton at Moore Johnson and Steele that have experience with that and know how to draft those documents so they'll pass scrutiny with the Internal Revenue Service.
What about revocable living trust and like special needs situations? Is there additional language that you put into the trust to allow for a separate trust upon the last person's death?
You could do that in a will as well, or a trust. The special needs trust is helpful primarily to maintain. So a special needs trust, for those that don't know, is a trust that's set up for those that have learning disabilities or aren't able to children that aren't able to take care of themselves and will never be able to take care of themselves.
Is it written differently for special needs than it would for like a spendthrift? Or is it kind of the same language?
A spendthrift is going to be more of, it's just general trust language. It's going to be anywhere, and it's going to kind of
spendthrift is you get that child that's going to blow the $1 million or $10 million in a year, and you can put some guardrails on.
You put some guardrails, govern them a little bit, and say you're going to get the money for X, Y, and Z.
And you can do that in a will or
do that in a will,
or
create
a trust. Living trust.
You're going to have to create a trust. It will create a trust
upon your death.
To put those safeguards in there. But
a special needs is
for that child with special needs, and really the primary reason why we see folks use the special needs trust is because many special needs kids are able to have Social Security benefits and federal benefits.
Yeah.
And if you have too many assets in your name, then you won't be able to access Medicare, Medicaid, or not Medicare so much. That pertains to elderly, but Medicaid or Social Security benefits.
Right.
The trust will basically, whatever the child inherits will be in trust and not in their name. It can be used in the way the trust is drafted is to be used in certain ways to maybe make life a little bit more comfortable, have access, but you don't have direct access to the funds, because if you have too much income or too many assets, then you can no longer access
government
Medicaid or Social Security. So that's the primary reason why you see special needs trusts. And it's pretty important. Actually, we were setting one up last week, for a sister who's a legal guardian, and her mother wasn't the best at in taking care of his money, so she took over as legal guardian. But when her mom dies, everything's going to go to her son, this girl's brother, and or our client's brother. So she's the daughter, our client's daughter, and her brother's the one with special needs. So when their mother passes away, assets are going to come to them 50-50, and those assets, the size of the assets, it doesn't have to be very much, will blow his ability to receive Social Security benefit, which he's been receiving for 25 years. So the special needs trust, when his mother does die, will go into the trust. He'll be able to continue to access Social Security, and then he'll have a pot of funds that his legal guardian, his sister, can access to maybe make his stay more comfortable, maybe a nicer sort of convalescent care or nicer places, and be able to purchase things that would make it a little bit more comfortable, but not imperil what's paying for most of his care, which is that Social Security and Medicaid.
Right. So when it comes to estate planning and business owners, what guidelines are you giving business owners in relation to passing of businesses? Like, let's say you have an S corp or an LLC that's part of your estate. How does that typically handled by the court or through your wills or trust?
Typically, we're going to have, or the LLC operating agreement is going to have a buy-sell agreement in there. Typically, if it's owned by multiple partners, you're not going to want to have
So it's more controlled by the operating agreement than it is inside the...
Because really what you're passing through will or trust is the membership interest. You're not really passing the business. You're passing the stock or the membership interest that owns the business. The business is an entity of itself.
Right.
It's going to have a manager, or if it's a corp, like you say, a president or a vice president. So that's kind of it controls itself, but it's owned by someone, and that's what would pass via will or trust.
And then the membership change would trigger the bylaws.
And so hopefully you've had, if it's a buy-sell arrangement, then that entity would have bought insurance on who has passed, and the other surviving partner would then have a pool of funds to buy out the estate, which is just inherited the membership interest or the stock of that business.
Right.
And, depending on the value of the business or the value of the individual share, you may want to put it in some sort of asset protected trust to kind of limit, how successful the business is. You may want to put it in a trust that, we see, and this is a lot of work that Brian and Sean do, and my other partner, Matthew Howard, would be to figure out the best way to put it in trust in a way that it's maybe gets a discount in the value of that trust, or you put the value of the membership interest of the stock in the trust, get a discount, and then if the business grows, it's out of your estate. So if you put it in and it was worth $500,000,
right,
it went gangbusters over the next 5 years, and now it's worth $25 million. Well, that $25 million is not in your estate, and remember, let's say $30 million.
Right.
Now you don't owe the estate tax because it's not in your estate; it's in this trust. And you were able to put it in when it was only worth $500,000. So all that growth was outside your state, and you don't have to pay estate tax. So,
and none of that impedes the operation of the business. It's it's just ownership structure.
Because you're going to have a trustee in place that you trust to and that could be a corporate trustee, which like a Raymond James or any corporate.
Do you have in regards to corporate trustees? I mean, that can get real expensive. Do you have like a go-to firm that you're using for that, or people, or?
I've used Raymond James a lot. But I don't have a strong. I usually recommend Raymond James if someone else doesn't have.
Is that because you have one person there that you have a relationship with, or
I just think
you just know their trust department?
I know their trust department.
Have you ever used Cumberland Trust?
I haven't. No.
It just gets floated around in the RA space so much.
Right.
And I actually called them on behalf of a client recently. The fees are very reasonable. It's a $2 million minimum.
Yeah, and that can be the thing.
And then their job is going to be to basically pay the bills of this daughter who'd be left behind in a spendthrift kind of situation.
Exactly. Yep.
But yeah, it was a $2 million net worth minimum, and they were kind of like right there. I didn't know.
Yeah,
that smaller space there's not much.
It's tough.
It takes an individual person to service that, not a company.
$2 million's usually, that's a pretty good minimum. Raymond James, I guess back to your question, I do have someone at Raymond James that will sometimes take, you can have some things pushed through and take a lower amount. It probably isn't economically feasible for any corporate trustee if you're in that $1 million to $2 million range.
It
really
sense.
Find someone that you trust, a family member if you're at that level. But when it starts to get to 5-10 million, when it really starts to make, and you're talking about some serious money, you're gonna want a disinterested party, i.e., this corporate trustee, to be making this determination.
Not confused. Raymond James is a lot of things. They have a very confusing business model, but their trust department is not managing assets. They're taking control of the situation.
That's right.
But they're not managing assets.
That's right.
The asset manager could be anybody.
That's right. Absolutely. And it would be who you decide to hire. You can put that in the trust document as to who you want to manage the assets. You could leave it up to the trustee if you wanted to, that corporate, but you could.
In that case, it probably ends up Raymond James.
Yeah, probably. There's probably pretty strong, pretty good guess there. Possibility there.
Raymond James is so confusing because they have an independent arm. Independent advisors like me could broker at Raymond James.
Right.
Then they have a hybrid model where you're part broker, part independent, which is, I think the government should get rid of that model. It's very confusing to the consumer. And then they have the whole classic Raymond James, and then there's Raymond James Trust Department, but it's all Raymond James. Mm-hmm. And I just scratched my head going, I don't know which part of Raymond James you are. Are you and me, or should I hate you? I don't know how this. I don't know how to have this conversation.
Well, we can cut this part out if we want to talk about Raymond James.
No. It's they're trying to evolve with the times, I think, but there are just advisors that are stuck on those selling insurance and life insurance and selling annuities, and they can't seem to do the math and open their eyes that working in the best interest of clients is really what they should do. But they've created a whole new channel for that. But I just didn't want our listeners to think that any Raymond James advisor could be a trustee of their.
That's a good point. Yeah, if you see a Raymond James a shingle, they're probably not any corporate trustees in there. That's going to be a separate department, probably out of
not in Atlanta,
St. Petersburg. I think that's where their headquarters are.
Correct.
So. But there's plenty of other corporate trustees out there.
Well, your Truist, your Wells.
Absolutely.
I mean, they are all traditional. Have traditional trust departments that are fiduciaries that will would help settle settle your estate. You just got to have a big enough one to justify what they're going to charge.
Right. And I think a corporate trustee also is a good idea because it takes, when you're talking about the sort of money that justifies having one, you're going to be putting that kind of a bullseye, for lack of a better phrase, potentially on a family member to have to
navigate through that.
Yeah, distribute these assets, and they're going to think that they're biased. You know, you didn't give me money because you are mad that I beat you in basketball when we were, when we were teenagers. You know, things that you just that shouldn't have to deal with. You know, let's a disinterested third party. Now you got to pay for that, but I think it's worth it in a lot of instances just simply because it does take that added pressure off that person. And that person might be, you know, a legal guardian of someone. You know, maybe someone dies early and you're taking care of their children. Those people probably shouldn't be the trustee because...
Well, that's a really good point because so let's bring it kind of back off of businesses. Most of our listeners are not business owners. They're retirees who probably used to be in business ownership at some point. But let's talk about that for a second. If you have younger children, and I've always thought it was a good idea to have a person in charge of the children, right? But then a different person in charge of the money. If you have enough people in your family.
That's exactly
that
right.
Seems to be a foreign concept to a lot of people that I talk to. But it's like, it only makes sense. Why would you want the person in charge of the child to also be in charge? They're going to justify every single expense.
That's exactly right.
You really should have a check and balance.
You'd like to think that it would be, and I think, you know, probably a fair amount of people would try to do it objectively, but it just, again, it takes that gray area out, that ability to be like, oh, you know, my brother's, you know, I miss my brother Joe. I'm taking care of his son. He needs money for school tuition this year. So does my kid. I'll just take out $50,000, and you know, money's fungible, so it just gets blurred, and then it becomes a slippery slope. You just remove that from potentially happening.
Right.
So yeah, I definitely think we strongly advise it should be two different people for sure. Kind of checks and balance.
It's okay to have like an allowance to say, well, these 3 children are living in your house. And,
absolutely.
And you know, if it's a large enough estate, you say, yeah, we need to add on or we need to move, and that can be arranged, but not like buying the whole house.
Sure. Yeah, exactly. No, absolutely. There are instances where, you set up you're taking care of, you've got more people, so more expenses. You're going to have some amount of distribution that makes sense.
Those famous stories are these child actors, and they become of age, and there's no money.
No spendthrift clauses, right?
Right.
A lot of professional athletes as well.
Yeah, that's right.
Yeah, I think a lot of these leagues are starting to do a much better job of trying to educate some of these guys and girls that are coming out and participating, making more money than they've ever had, and let them know that this is a short duration. You'll be here you'd be lucky to be here 5 years, 6 years. You know, some can be even shorter. Take this money, sock it away, and do some advanced planning. And there's folks out there that do, you know, estate plan that just do it for athletes and for people in the entertainment industry. So, it's a good point.
Well, bottom line is we should never hate our family, and we should clean up our own messes.
That's right. I think personal responsibility. That's really. This is in that vein of personal responsibility. It's these are your assets. Someone's going to have to deal with these assets after you're gone. And a lot of times it's going to be, for lack of a better phrase, somewhat of a windfall for the next generation. So there is a sort of a benevolent component to it. But for a couple, you know, $1,000 to $2,000, you can make that whole process a lot easier than by not doing it. So while I understand it's not anything that people want to talk about or want to stay focused on, and a lot of questions we ask are things that people never even thought of, but it's vitally important, and your children are going to be much appreciative if it's been done and it's been done correctly. So even if you don't use MIJS, use somebody that is that has experience, that has the bench depth to deal with these types of issues, and you know, it's no problem to ask around. You know, some firms will charge a lot for this because they have to get a minimum fee, and there's other firms out there that'll charge what it takes. And so that's sort of my last parting advice in terms of, you know, I would think for that general level 1 planning is going to be, you know, level 1 planning is what I call the wills, financial power of attorney, healthcare directive, about $1,000 for a married couple. That's 6 documents, 3 each.
Yeah. That's a great price, by the way.
Yeah, 1,000 to, 1,000. Some folks do more, and that's not unreasonable either. You start getting into $5,000 for those 6 docs. That's a bit unreasonable in my opinion. And there might be some other things that they're doing, special needs trust, revocable trust. That's all going to be additional cost to it. But
Sure.
That basic level one is if you're not getting a flat fee or at least a reasonable estimate on an hourly work for that, then you might want to check around and find someone, because there's plenty of very good attorneys that can deal with that at a reasonable cost.
Our theme for this quarter is financial success is intentional, and this is an intentional step that you have to make for your family. You can't we've had a couple episodes already on setting goals and obtaining goals and waking up each morning with a purpose. And reason why we have a podcast with you today is because this is something that we have to focus on as professionals and good family members, is making sure that we've buttoned up our finances for the next generation. You were in a podcast prior. We talked more about legacy planning, where how do you take these same documents and add something to it that you had a great idea of with writing a letter,
Right.
and attaching that to the document. So the next generation, there's a little more heart to it.
It's not so transactional. It's really
Correct.
like a heartfelt gift, and
Correct.
It's it doesn't happen all the time, but when it does, you can really see that it's pretty meaningful. So that's something we've seen that's been pretty touching.
Yeah, probably solves a lot of family squabbles too.
Mm-hmm.
And there's a letter on top.
These are my wishes.
This is my wishes. This is why I did what I did, and it makes it very clear so people wondering.
Yep, that's absolutely right.
All right, Doug, thanks for your time. Thank you for
thank you
all
for
your hard
having
work and your team as well. And hopefully we'll have you back again soon.
Well, thank you for having me, and thank you for trusting us, and always enjoy speaking with you. Thank you to the Wiser team.
Thanks for listening to a Wiser Retirement podcast. We hope you enjoyed today's episode. Make sure to subscribe wherever you're listening. That way you don't miss any new episodes. We would also appreciate if you could leave a rating and review. If you have any questions about anything that was discussed today, head to wiserinvestor.com and reach out. We would love to hear from you. This episode was produced and edited by Lilton Moore.